Number 1 is 4 to 3. It is the best one.
Which of land counts for the appellant? Coming up on the dismissal, you can make a mention when it comes. Dismissal matters, please don't make a mention in the morning. Yes.
22 to 27.
Item number 21. Yes. It is submitted that the appellant died. They'll file an application bringing the alerts on record. Post after 2 weeks. Yes. Why? From 2015 to do it. My request to all the advocates is please don't ask for time, and particularly this MFA. Finally, after 2 weeks, no further time will be granted at the request of land council for the appellant. Yes. Yesterday it was heard. Yesterday it was heard. Have you informed Mr. Mahesh? Yes, Mr. Mahesh, item number 17. He wants time till Monday, post on Monday. Yes.
Number 28 to 35. 36 to 43. 44 to 48. 49 to 53. 54 to 57. 58 to 60. Number 1 to order.
Sorry, my lord, for interference, short, only one submission, my lord. Serial number 23, my lord, I am representing a respondent insurance company. Srimati Bhushani Kumar is out of station. They have requested me to make a mention to the court.
It's already adjourned.
Oh, sorry, my lord. Sorry.
It is adjourned.
Oh, sorry, sorry.
Yes.
Number 1.
Yes. It is on 7/8/2022. Why it is directed to be posted today? Yesterday it was. Please look into that. All the matters. Is it posted today? For service of notice. No. Post this matter after 1 week. The notices are not served.
Number 2. Ravishankar CR.
Yes.
Dispensation of afterwards.
No, file an application. Already that is done. The notice the owner of the vehicle respondent number not. No, this is an appeal by the insurance company. Confirm it. No, in that case, why the notice to the let us see the order. Please come to the order.
Madam, yes, picture is allowed. That is, page number 18 of the. Picture is allowed. Point. Picture is exactly a total sum proposition of 35,000. Percentage. Okay. Rate of decision range. Second response is there to deposit the same with respect of the.
Please come to issue number 1. Let us see that first.
Number 1, page number 5 of the page. Because the petitioner is, but he is, they are certain various things so that traffic accidents and occur on to the day. The private bus stand, they stop on Bangalore Metro Road, like India City. Due to rashing and panel of the rating of the motor vehicle, K02ED, 4033, hidden by its drive. If it's so, then
So basing on what you're saying that this finding of the court that there is a negligence.
Issue number 1.
Yes,
In order to the petition himself, it can be done one. But an appeal, evidence thereby, reposes that as on the date of the act, the legal belongs to the respondent agency during the labor, here and that and clearly, hereby dash it against the petition and cause of the act. And the driver of motorcycle, 66 author of the accident. In support of the evidence, the got renewed to PC. Other petition I got examined on the wedding, which was also support. People were getting that they are now get up there. Thank you.
here's the record. Yes. So what else you want? The court says that PW1, PW2 by his evidence which corroborates the evidence of PW1 has proved it. And you couldn't elicit anything from the evidence of the from the cross examination was a finding. It's not received or not being. You have to see the docket. Yes. So, according as per the observations of the court, PW1 and PW2 have stated about the accident and the negligent manner in which the driver of the offending vehicle was driving. Basing on that, and the court also observes that you have not elicited in anything in the cross examination. Yes. Return back. Yes. Who are the witnesses that they examined on your behalf? And they have examined the eyewitness. There is a copy of the FIR. So there is basis for the court to answer the said issue. Then what about the compensation? What are the injuries sustained by him? So let us see issue number 2 also. Confirm the fracture of neck of right femur, hip joint is grievous in nature. As far as pain, the pain and suffering is concerned, for the grievous injuries will increase the amount. Other heads would remain wound certificate. No, it is 15,000. Will grant 40,000. Only the injury, pain and suffering. Other things would remain. Huh? No, it's a fracture. So only for the fracture, towards pain and suffering will grant 50,000. Please come. Not 50,000, 40. Yeah, it is the agreed by the award passing, MEC number 357 of 2009. Both the insurance company as well as the claimants have preferred the appeal. The appeal of the claimant, the insurance company is numbered as MFA number 491 of 2017. And the appeal of the claimant is numbered as MFA number 11129 of 2012. The claim petition is filed seeking compensation of an amount of rupees 5 lakh with interest at 18% per annum from the date of accident till the date of realization. It is the case of the petitioner that on 29/6/2008 at about 9:15 a.m., the petitioner was going from Factor Circle side towards Nandi office, Mandya city on the left side of the road. At the time, one motorcycle being ridden by its rider rashly and negligently dashed against another motorcycle who was taking turn towards the private bus stand, and at the same speed, in a rash and negligent manner, dashed against the petitioner from behind, due to which the petitioner fell down and sustained injuries to both hands, face, and other parts of the body. It is a case of the further case of the claimant that he was treated as an inpatient. An X-ray was taken. It shows that there is fracture of neck of right femur. Hip joint is grievous in nature. POP and LS belt was applied. The petitioner was treated as inpatient for about 15 days, and he has been to take 50,000 for medical expenses. And petitioner requires future medical expenses or rupees 25,000. Since the doctor has advised to undergo surgery if necessary. He has also spent an amount of rupees 25,000 towards food, diet, and transportation charges, and 250 and rupees 250 to the attendant per day. According to the claimant, he was doing mason work and earning an amount of rupees 6,000 per month. Because of the injury, he could not work, and there is loss of income. The court below, on the first issue of negligence, has held that the claimant had produced 6 documents, that is exhibit P1 to P6. He has not examined one witness by name Umesh as PW2, who also supported oral evidence of PW1 by stating that as on the date of the accident at about 9:15 a.m., the driver of the offending motor vehicle was driving his vehicle rashly and negligently, thereby caused the accident. The court observed that the respondents have subjected both the witnesses to cross-examination, but nothing is elicited from them in order to disprove their contentions. Further, the police documents also suppose the claimant, basing on that the court held that the accident has occurred due to the rash and negligent driving of the driver of the offending vehicle. When it comes to the compensation, basing on the wound certificate and the X-rays, which shows that the petitioner has sustained a fracture of neck of right femur, hip joint, which is grievous in nature. Though the claimant has stated several things about the treatment and the amount spent by him, as he has not adduced any evidence, and as he has not as he has not examined the doctor, the court has not considered either the disability or other aspects. Only basing on the wound certificate, court has granted towards simple and grievous injuries an amount of 15,000, towards hospital medical expenses 5,000, food, diet, transportation and attendant charges 5,000, towards loss of income 5,000, towards physical pain, mental shock and inconvenience another 5,000. Total in amount of rupees 35,000 is granted. Then counsel appearing for the insurance company submits that there is no evidence. It submitted that the claimant has failed to discharge its burden and failed to prove that the accident has happened because of the rash and negligent driving of the driver of the offending vehicle. It is submitted that when he has not examined the doctor, the court below ought not to have granted the compensation. There is no representation on behalf of the learned counsel for the respondent, the counsel for the claimant. As this is an appeal of 2017, the court is inclined to your appeal. That's what I'm saying about the claimant. That time I've already recorded your contentions. That is over. And the land counsel appearing for the claimant is not present. As is an appeal of 2017, this court is proposing to decide the same on the merits of it. In the grounds of appeal, it is stated that the compensation that was granted by the tribunal was not reasonable. And when he has sustained the injuries and spent huge amounts, and also and when he has sustained the disability, the court below has failed to take into consideration any of these factors into consideration and granted a meager amount of 35,000. First, coming to the contention of the land counsel for the insurance company, that the claimant has failed to prove the negligence on the part of the driver of the offending vehicle. This court has perused the order passed by the court below, wherein at issue number 1, the court below has observed that the claimant has examined as PW1, the pillion rider as PW2, and also marked exhibit P1 and P6. All these documents flinchingly prove that there was negligence on the part of the driver of the offending vehicle. Court has also observed that the respondents could not elicit anything from the cross-examination. In the cross-examination, further relying on the exhibit P1 and P6, court came to a just conclusion that the accident has happened because of the rash and negligent driving of the driver of the offending vehicle. This court do not find any reasons to interfere with the said findings of the court below, which are based on the evidence available on record. Then coming to the issue of compensation, as rightly contended by the land counsel for the insurance company, the claimant has failed to examine the doctor to prove the disability, or examined the concern to prove the medical bills that was spent by him. The court below has rightly not granted any amount under the head of disability and about the other amounts spent by him. The court has considered the wound certificate and held that he has, which was not disputed, and held that the claimant has sustained one grievous injury. For one grievous injury, the claimant under the head of pain and suffering is entitled for an amount of rupees 40,000. The court below, though there was no evidence, has granted on a guesswork towards hospital medical expenses 5,000, which holds good, towards food and diet transportation 5,000, towards loss of income 5,000, towards mental shock and inconvenience As this court has already granted under the head of pain and suffering, under this pain, mental shock and inconvenience, 5,000, this court is not inclined to grant altogether. The claimant is entitled for an amount of.
Sorry, my lord, in this case, I am appear for the connected appeal appellant. I am in this case.
Where
Sorry,
were
ma'am.
you?
I am in the DRT, my lord. Sorry. My presence kindly.
The non-counsel for the appellant is not present, that is, the non-counsel for the appellant argues. 55,000. Total amount the court is meant.
Much obliged.
Accordingly, the appeal is allowed by enhancing the compensation. Like, appeal of the claimant is allowed by enhancing the compensation from 35,000 to 55,000, and the appeal of the insurance company is dismissed. The amount already
Much
deposited, deposit made by the insurance company shall be forthwith transferred to the court below.
Much obliged, ma'am.
Right.
Sorry, ma'am.
Right. Yes, next matter.
Someone clarify it.
For what? Huh? Why are you not no, but I'm requesting all the advocates, by the time the matters come before the court for orders, by the time we should take steps. Ordinance will dismiss it. Because for an appeal of 2017, for a process, why it should be adjourned today in 2023?
Sorry, my lady, this first-
Finally, at the request of counsel for the appellant, post this matter on Thursday. By the time the steps are not taken, appeal will be dismissed on the ground. Yes, next.
Bill number 4. Okay, Headley.
So don't give me the docket.
Unsolved cover return with postal Shira. Adresi inquiry not known. 7 days inquiry. Go for the second time.
How many times you were granted time?
I think it paid, but it was not supposed to be exponent number 1.
Where is that?
It's written in the docket that it's not been served. Adresi 7 days inquired not known. So notice has to go for the second time.
When is that acknowledgement? When was it received?
2018, 21/12/2018.
18. That was in 2018.
Today itself, again, there.
The non-counsel for the appellant it's time. The taking step post after 2 weeks. By the time the steps are not taken by the appellant, appeal will be dismissed on the ground.
5, Prasad.
Was this matter? 2 weeks. Same order in this also.
Number 6, PCC Karnataka.
I appear for the appellant, my lords. I'll take steps today itself.
Same order.
7,
Yes.
Bill number 7, RD Karnataka.
All the respondents are served? Yeah, you appear for the respondents? Yes. What's the case about? Let us see that finding. Let us read from issue number 1 to understand the fact.
Stated that the writer of Honda had not taken negligent the Bajaj discovery. I find no fault in this ambiguous evidence for the reason that firstly he was the million writer of the Bajaj discovery. Secondly, accident occurred at 9 p.m. in the night hours. It's well known that in the night hours vehicle move with the red lights on, so it will not be possible even to see the rider. Thirdly, as explained by him in cross-examination, the rider was wearing helmet. Therefore, the evidence of the was of no use to identify as to who was riding the in part of the evidence that one more is competent to come and depose in favor of this petition. After reading the written arguments of everyone, it has a see Bajaj discovers motorcycle rider and filed claim petitions number 890 of 09 and 891 of 09, and they came to be allowed. It was held that Honda Activa was written by the petitioner, who was admittedly a minor at the time of the accident. The claimants in the said two cases have toiled to recover compensation against the respondent number 1, who is the father of the petitioner as well as the owner of the offending vehicle. If it is stated that the respondent number himself was riding this scooter vehicle, that will ease the claimants in those two cases in realizing the compensation from the insurer. There is a reason to make all these observations. It may be noted that the respondent number 2 cross-examined PW1 on only one line of defense, stating that it is the very petitioner who was riding the scooter. At this stage, I may also say a few words about the conduct of the petitioner in abusing evidence. His SLC marks card produced at Exhibit P11 shows his date of birth is 26/1992. The date of accident is 5/1/2009.
You know, what is the case of the claimant? There is some confusion.
The accident occurred on 5/1/2009 between two two scooters. One is motorcycle KA41H509. One Papa Raju was the rider.
Which is the offending vehicle?
In that case, the offending vehicle was KA41J9955, who is the petitioner in this present case.
Two claim petitions were filed.
Three claim petitions.
So there are two vehicles.
Two vehicles.
Yes. Yes.
Date of accident is 5/1/2009. Accident between two vehicles. Motorcycle KA41H509. It was ridden by one Papa Raju, civilian rider, and Maula TL.
Maula?
Maula TL. The Papa Raju dies in the accident. His LR's filed NVC 890 of 2009.
2009, yes.
The civilian rider Maula files NVC 891 of 2009. alleging negligence against the rider of the motorcycle KA-41J and
1 minute.
KA-41J 9955.
They are the claimants in this.
They are the claimants in this.
9955.
In that case, we took up a defense that this vehicle KA-41J995 was insured with us. It was being driven by this minor boy using field. Unfortunately, our pleading in the written statement was complete. We relied at the time of the evidence, we relied on exhibit R2, not its concentration. Man's medical record showed that this minor boy was writing. The court said, look, you have no pleading. So any amount of evidence without pleading is of no consequence. They rejected my defense and they fashioned liability on me on the noise that you are trying to establish that the vehicle was indeed driven by a minor boy.
And that it was held that it was negligence on the part of this boy.
With that, I also placed that judgment. I filed MFA out because some of the court, but then this court also said we have not pleading.
They were allowed. They were dismissed.
Those two MFAs. So far as this case is concerned, I was able to place the defense on according to the defense statement. I also produced evidence, not only of demands, but also the other medical hospital. But it is clearly said that this boy.
No, one issue is whether you adduce evidence or not. In respect of the very same accident, if a particular vehicle is held to be negligent or it has become final, so it will operate here also.
I would like to report a business statement now. Yeah, they are an appeal challenging the business law.
Yes. No, I understood. Yes.
This case, I may also say a few words about the conduct of the criminal abusing evidence. His SLC marks start with the 11 was the date of birth as 26/99. The date of accident is 5/1/2009. So it means as on date of the accident, he was a minor. However, on the date of examination, his mother PW1 on 2011-2010, he had already attained majority, but he did not come forward to meet his evidence. Instead, he went in convenient because guardian discharge after the examination. Leaving aside these questionable conduct, I will turn to the case sheet of Sagar Hospital, which is a sensitive field emergency case record remand notice as related article by case sheet at page 9 of 6/1/2009 at 1 AM. The time of admitting the petitioner to the hospital, history of injury was recorded as 15-year-old male patient admitted to hospital. SRT on 5/1/2009. Patient riding on a two-wheeler with against other two-wheeler. They have passed into a gate in Cook India. Similar endorsement has been made in the consultant overseas on very quickly. The auto part of the case, that the two phases and the endorsement treated that taken one or release. Although there is an endorsement in the case that it is kind of brain whatever. That view of matter.
Yes, Mr. Khan, please come. This matter, there is an appeal filed by the payment. Agreed by the about passing NVC number 1007 of 2009, dated 14th August 2011. The claim petition is filed seeking compensation of an amount of rupees 10 lakhs for the injury sustained by the claimant in the accident. The case of the claimant is that on 5/10/2009 at about 9 PM, when the claimant was proceeding on the Hero Honda Activa as a pillion rider, the rider of the scooter rode the same in high speed and in a rash and negligent manner, and having lost control of it, went to the extreme right side and dashed to the Bajaj Discovery motorcycle bearing number KA 41H509. Did I tell you the number of the car, the vehicle? That scooter bearing number KA 41G999. Due to the said traffic, due to the said impact, petitioner fell down and suffered grievous injuries. The rider of the Bajaj Discovery scooter succumbed at the spot. After the accident, petitioner was taken to the hospital and was treated there. He was referred to Nimhans and Sagar Hospital for further management. The respondent number 1 is the owner of the scooter and respondent number 2.
Sorry, my lord, serial number 7. I held up. My lord, I am for owner of the vehicle. My lord,
Yes.
my lord,
No, the court is going to dismiss it.
No, I am submitting. It is not a case for dismissal because, my lord, the accident between two motorcycles.
This is an appeal of whose appeal is this?
It's the claimant's appeal. The
Then
claimant,
how are you concerned with it?
my lord, what happened is, my lord, he is my son. Son claimed the compensation against the father's vehicle stands in his name. My lord, what happened is, my lord, there is a two motorcycle. That is why I am submitting, because he is my son and we incurred about 1,89,000 towards medical expense itself. My lord, what happened is there is a two dispose of matter was kept below. It is now disposed of. My lord, what happened is, my lord, there is a two motorcycle dashed against each other and a two person died who are traveling in another vehicle. My lord, the contention of the insurance company is, my lord, I being the RC owner, now the petitioner is the son. He was riding that motorcycle. That is their contention in all the cases. My lord, may kindly see the dispose of matters file. My lord, what happened is, my lord, the tribunal, after coming to the conclusion that, my lord, I myself, I being the owner, was riding the motorcycle. There is no controversy on that point, and found that I being the owner of the vehicle, riding the motorcycle, and company held liable. My lord, that judgment is challenged by the insurance company, and now that is disposed of. They withdrawn that appeal. My lord, same contention is taken in my appeal. That is, my son filed the appeal. My lord, in that appeal, my lord, the finding is, my lord, my son was riding the motorcycle. My lord, now my son preferred the appeal. Well, since in view of these two awards satisfied by the insurance company and withdraw the appeal filed by them, and in view of the finding of the tribunal in that two claim cases,
Is that order?
It is kept below.
No, where is that?
I will inform the appellant advocate if my lord have it on 16 or 17, because
No. Court will not wait for the advocate to come. He has to come when the matter is discussed.
since he is my son, that is why. And
no, whatever it is, court will hear you, and court will not wait for the appellant counsels to come.
It is kept with this file, my lord. These two appeals are kept disposed of.
Yes. We will look at that. So let us see the particular finding given by the tribunal in that. Yes, no, it's here. The legal heirs of deceased Paparaju.
NBC judgment is there.
Yes, it's there.
Page number 6 of the judgment. Page number 6.
Yes. Para 13? Yes.
We come to
This
page
is the contention.
page 30. Just taken to the state of the respondent review. What amendment review? Then I do not take up the defense. For my contention that the minor boy was riding the for this belief. And I also told this honorable court that I find the MFAs, I will do it. But in the connected case, I led in evidence, I took up a defense, court has accepted.
No, but the difficulty is there cannot be two different stands of the insurance company in respect to the very same accident. When the findings have attained finality, now there is a question of deciding, what will happen is, if he is a pillion rider, in that case, the insurance company was not liable.
Is not totally clear. The minor child was riding the bike. He sets up his father as though his father was riding the bike. Then we took up a defense line. The father is not injured. The accident, who are injured is only this minor child and the opposite, Papa Raju and Mola. These three people are injured. There is no claim petition.
No, we will look at the findings of the court. What did the court say on that, on the rash and negligence?
On that,
Absolutely, there is no material to show that son of respondent number 1 was riding a motorcycle.
So far as issue number 1 is concerned, Lord, he sustained contact with the rational negligence. He was going on motorcycle, repairing the this is the issue number 1. It only says that if there is no finding as to speaking as granting it in fact, the court only says that he said accident, he sustained injuries. Are legal.
No, assuming that he is driving the vehicle, he is the owner of the vehicle. He is the owner of the vehicle. Assuming that he is driving the vehicle, that is the father, not the son. Now, when he is the owner of the vehicle, he is entitled for personal and accident coverage. That also will be applicable in case if there any bodily any disability or some loss of limb and other things. What has happened to him in the?
Nothing has happened. He-
So let's not go to that. Let us come to this part.
Who indeed was the rider of the scooter. And he finds the case, contending that he was the million rider. His father was riding the vehicle. Nagaraju is his father. He says his father was riding the vehicle. It's a separate case. This is tried against the other vehicle. And it is not, I'm sorry, it is not even tried against the other vehicle. It's tried against his own father. I'm being sure this vehicle. I say that no, you were the rider of the vehicle, your father was not riding it. They have proved it.
What is the policy?
That is the main point, my lord. If it is not a package policy, there is no point in claim the compensation. If it is
Comprehensive
act
one.
policy, if it is act policy, my lord, I am out of court.
The issue is not whether what is the policy. The issue is whether who was the rider of the vehicle. Whether a fraudulent claim has been made.
That is now concluded.
Fraudulent claims. The rider vehicle was being driven by him and the boy. They set up the case as though the father was ready. That is the categorical finding when you learn it, judge. And the father who the rider, he did not step, he is obviously in position with the son. He has no say in this matter here. In petition is dismissed, he has not paid the appeal. It's for the claimant to come before my lords and say that yes, the reasoning of the MSC is not proper. First respondent, owner has no say in this matter. The fact that he is holding order for his son itself was the offense for him. Conduct itself speaks for itself.
Before the court below in the other case, what is the evidence produced by the insurance company to show?
Not even taken the plea properly. Court said, at the time of evidence, we brought on this same exhibit R to the Remand's medical records. The court said, boss, we have not even pleaded. Why is the question of letting in evidence?
So what is the evidence left in this case? Let's see.
That is what I read out.
Yes. Again, no, in the light of this, we'll see that. Yes.
PW Insurance Company. Another important thing, my lord. OD claim has been settled by the insurance company. Own damage claim has been settled.
Can you see me? From that time onwards.
No, let us see. So let us read from 9. Yes.
But I read from Bala 7 itself.
Yes.
In case of the respondent number 2, that the insured and the scooter owner respondent number 1 is another than the father. On the date of the accident, the petitioner himself was riding the Honda Activa scooter. Because of his negligence, the accident occurred. It is further contained the respondent number 1 by managing the road to restrict the facts. The case was registered as if he himself was riding the scooter. Thus, it is contended that since the minor petitioner was riding the scooter with the knowledge of the insured respondent number, it is not liable to identify the insured. Therefore, we have a specific plea in this case. It was absent in the previous case. Now, the point is whether respondent number 2 is able to prove its defense or the petitioner is able to establish his allegation. As I have already stated, the petitioner examined his mother as PW1 who her court part, the police documents, his FIR complaint, mother, early report, state charge sheet, and news. On going through the said documents, one thing is evident that the complaint was filed by a person by a relative of the deceased, right of the Bajaj discovery as a circumstantial evidence. Witness, the complaint itself shows that he came to the place of the accident after its occurrence. Looking at the public camera, he immediately went to the place of accident and coming out that the deceased is his cousin by. Therefore, it's needless to say the complaint otherwise not that they have yesterday. Now the question will be what is the value of the party with this case? I think that will require a little more elaboration. So before I got the charge sheet, let me turn the evidence of 51. It is needless to say that she is also a hearsay witness. Witness left out this PW2. If anybody goes to the testimony of such witness, it will be seen that the he was first was writing the Honda Activa was called. In examination, he all around stated that the radar of Honda Activa will be I know what will be the accident well known that he is explained by him in cross examination. Was very heavy. Therefore, the evidence is to identify who was riding the vehicle. Before we pass the evidence, more reason
ಓ ಮಧ್ಯಾಹ್ನ ಇವ್ರಿಗೆ ಹೇಳ್ಬೇಕಲ್ಲ ಓ ಕರೆಕ್ಟ್ ಒಂದೂವರೆಗೆ ಅಲ್ಲಿ ಮುಂಚೆ ಇಲ್ಲ
ಎಂ ವೆಂಕಟೇಶ್ ಆಫ್ ಮಾಡ್ಕೊಳ್ಳಿ
the father of the petitioner, they are also number 1 and himself writing the cases in parents, those 2 cases, there reason to make all these. We noted that respondent first examined PW1, 3 on the line of defense stated that the very petitioner who was writing the scooter
this stage, I will also say about two words in order to be SSLC marks card. Date of accident is 5/1/2000. So it means as of the date of the accident, he was a minor. However, the date of examination is smaller. PW1 on 2011-2000. He had already attained the age of still even convenient to get us back in. Leaving aside these Fifteen-year-old male patient. Here you are. I am talking here of 5/1/2009 after the calculated patient riding on a two-wheeler in another two-wheeler. Similar endorsement has been made in the consultant code, page 7 on the very same day of 12/28. It also part of the patient as a home basis, there is endorsement. Patient particular or a scooter. That will not on the basis, these are document at an undisputed point of time. The court is also a court is case in the NWK or medical records. There is no reason for the doctor to have recorded all these things. He has no axe to grind. These are documents at an undisputed point of time, at the earliest point of time, before the police could enter into the court has accepted these documents. I have proved my defense that this minor boy was writing the case. Each case has to be independently assessed. So far as the negligence. We have established the court. The fraud cannot be perpetrated. Just because I am unable to do it in the earlier, it is not become binding on me as family source.
Now, in a discharge summary, what is mentioned is alleged history of RTA while traveling in a two-wheeler, hit by another two-wheeler. The court observes that he was riding the two-wheeler. That's not it. I'm looking at the discharge summary. It says alleged history of RTA while traveling in a two-wheeler, hit by another two-wheeler.
No, I didn't see money in the God is seeing there. Case sheet, page 9. Sagar Hospital, which is
1
at
minute,
exhibit
1 minute.
P20.
What I'm looking at is the Sagar Hospital.
Exhibit 10, exhibit P20, Manu.
They are given two certificates.
Exhibit P20. They won't know.
Riding on, that is the, and diary, and not. The wording used by the medical authorities, patient was riding on a two-wheeler, but it should be, if it is written as patient riding the two-wheeler, the effect is entirely different.
Being treated on a two-wheeler, not riding on two-wheeler. Don't try to print there. You know, understand. Exhibit P20.
Let's hear.
15-year-old male patient, admitted to CH-24 that patient riding on a two-wheeler hit to another person. He was riding and he hits another two-wheeler.
Page number 7 top. No, the word used is patient riding the two-wheeler. It is not written as riding the two-wheeler. It is riding on the two-wheeler, on a two-wheeler. It may be pillion rider.
When traveling in a two-wheeler, medical legal register also says that Sagar hospitals. No, court has to give a finding basing on the evidence. Court is looking at the evidence. Discharge summary says the same thing. Medical legal register says the same thing. Where from the court has inferred that? Is a question. I think you read it. The court is not able to read this. Medical legal register. Please come.
Patient riding on a two-wheeler, it is written, not patient riding the two-wheeler. Is on, the word used is on. Madam, may I make one submission? If my lord permits.
Please wait, Mr. Counsel, the last thing. First, we look at that medical legal register. What is exhibit P20? Case sheet. Now, before the case sheet, the moment he has come to the hospital, the medical legal register will be there. That they have written it something else.
The earliest medical legal register is
It's the earliest. Please look at it, bottom of the page.
history of while traveling in a two-wheeler.
Yes.
Two-wheeler, by after two-wheeler at 7:30 p.m.
So it makes difference, traveling and riding.
Document is not marked. Document is not marked. So the Xerox copy, this document is not marked. Document is not marked. So the Xerox copy. Where is the exhibit P20 which is not here? While riding the two-wheeler, in fact, what the judges
Exhibit P8 is marked. Exhibit P8 is what is stated in the register is the same thing you find in discharge summary.
Exhibit
P8. P8 is just now I saw. There are numbers in the index in the beginning. There I think you will find. In the beginning, there is an index to what are the documents.
states others history of RTA while traveling in two-wheeler also. This is the discharge summary. And this the case sheet is at the earliest point of time, and it's just kindly first.
Both the documents are marked by them.
Copy document are not correct. Please see it. Writing is good. What before the extending is not correct. What is writing is good. Categorically as it can be.
This is on, this is not the earliest. This is on 6/1, 6/1/2000. Then the
Early morning, that's about midnight, 12:30 a.m. early morning. 30 a.m. Discharge summary is subsequent. On the date of the discharge.
no, if this medical legal register, if it is not marked, we will look into that because that says something else. It is also an earliest document.
No, it's on the date of the discharge. That is written on the date of the discharge.
Medical legal case.
What my exhibit PA
So P8 is a discharge summary. I was also looking at medical legal case that is on,
Five.
on 6/1/2009. That was on 6/1/2009.
Early morning, 2:30 AM.
No, at 12 AM is medical legal register.
12 AM is also.
In that they said while traveling in a two-wheeler.
Traveling in a two-wheeler. That is not, take it in a literal sense, traveling on a two-wheeler. It is now clarified that he was riding his two-wheeler. And also the judge also says, the progress sheet at page 11 on the same document. He also says, yes, that consent on the very same day. That also shows he was riding. So two places the court notices. And if the father indeed was riding, he would have sustained any such an impact. One person dies, another person is injured, this person is injured. Indeed, the father was riding the vehicle, he would have also been injured. He doesn't even come before the court. This submission is such prominent place.
Unfortunately,
What has given valid reasons?
you have let them have one claim, two claims without using any evidence.
And OD claim is also settled, my lord.
Those two claims, those two claims,
My
they were third parties, so far as I was concerned.
OD claim is also settled.
There were third parties. There was an issue who placed fraud on me.
So even in that case also, if the minor is riding the vehicle, there is violation of conditions. You can say that he is only responsible.
To establish my defense. Just because I am afraid that should I take this burden also, that would be unfair. But I have been able to demonstrate the fraud. I didn't do it at that point of time. I've woken up and I have not done it. Kindly appreciate it.
What is the other evidence now? If this this claim petition has to be allowed? What is the discussion by the court? Court has not gone into the other.
No appreciation is made. Madam, may I make one submission?
Even if the court comes to the conclusion that the court below is not right in discussing the claim petition and for granting compensation, there is nothing discussed in the order. Nothing is discussed in the order.
Remand, according to me, my lord, it's a fit case for remand because, my lord, there is some raising issue is also problematic. There is no proper issue is raised about the involvement and other things. First point. Second point is they are already satisfied the owner's claim, the OD claim. They are satisfied the OD own damage claim also. And third point is now they are same question was raised in other two cases that has been negative. The positive finding is there and they accepted, they satisfied the award. In this view of the matter, either it should be remanded for fresh evidence or to my claim petition.
When it comes to issues, I think on parity, there's no parity, it's not a case of parity. He's not a third party.
Please come. There's an appeal filed by the claimant agrees by the dismissal of the claim petition in NDC number 1007 of 2009, dated 15th August 2011. The case of the claimant is that on 5/1/2009 at about 9 p.m. You already wrote all that. I think the facts of the case you have written already. In what you have read, you have written before. What you have taken this before this.
Therefore, he has referred to enhancement. Therefore, he has referred to Nimans and Sagar Hospital for further management.
Have you said
This point number 1 is the owner.
It is a stem. The respondent insurance company has filed a counter, has filed a return statement stating that accident was not reported to them by the respondent number 1. And as per the information received by it, scooter was ridden by the petitioner, ridden by the son of the owner of the vehicle, who is the claimant herein, who had no valid driving license and who is not qualified to hold a driving license. The owner, having knowledge of these facts, handed over the vehicle to the petitioner in violation of the terms and the conditions of the policy. Now, by twisting the facts in collusion with the local police, the respondent number 1 managed the things as if he was riding the scooter. They admitted that it has issued a policy in respect of the vehicle, but its liability is limited to the terms and conditions of the policy. The court below has observed that in the accident, the other vehicle is involved is yes, it's in the book here. Here. The other vehicle is KA41H509. Other two-wheeler is KA41H509, which was ridden by one Paparaju and one Maula TL is the pillion rider. In the said accident, the said Paparaju died on the spot, and his alarms has filed MBC number 890 of 2009, and Maula TL has filed a petition for compensation for the injuries that is numbered as 891 of 2009. 2009. In the said 2009, and both the claim petitions were allowed. The insurance company in that case also has taken a plea that the owner of the vehicle was not riding the vehicle, but it is a son who is the claimant herein is riding the vehicle. In these two cases, the tribunal has negated the contention of the insurance company as there is no evidence in support of the same. Agreed thereby, they have filed MFA number 9437, MFA number 9437, 9438 of 2011, and both the appeals were withdrawn by the insurance company. In this case, the court below has observed that has considered exhibit P, exhibit P20, P20 and exhibit under evidence of liability. And exhibit R2. Exhibit P20 and the emergency case record of enhanced reduced marked as exhibit R2. In the case sheet at page number 9 on 6/1/2009 at 1 p.m. at the time of admitting the petitioner to the hospital, history of injury was recorded as 15-year-old male patient admitted of alleged RTA on 5/1/2009 at around 7:30 p.m. Patient riding on a two-wheeler hit to another two-wheeler near Tagachaguppe village, Kumbalgondu Post, Pengiri. And similar endorsement has been made in the consultant progress sheet at page number 11 on the very same day at 12:30 a.m. It is also part of the case sheet. Thus, at two places, there is an endorsement in the case sheet that patient was taken to the Nimhans. A CT scan of the brain was done there. Basing on that, the court has come to the conclusion that the patient suffered injuries in the RTA and he was rider of the two-wheeler. And the court observed that, that being the case, just for the sake of compensation or to avoid his impleading liability, respondent number one twisted the things in collusion with the police. Perhaps for the said reason, by filing the complaint, the Venkatachalaya did not say the name of the rider, even after alleging that victims were fallen at the spot, relying on a judgment of the apex court in the NWKRTC versus Gaurabai. The tribunal has held that the minor was riding the vehicle and answered the issue against the claimant. Aggrieved thereby, the present appeal is filed. When the matter came up yesterday, came up on 7th August 2023, there was no representation on behalf of both the sides, hence the matter is posted for dismissal today. Today, the learned counsel for the insurance company, today also, learned counsel for the claimant is not present. Learned counsel for the insurance company, as well as the learned counsel for the owner of the vehicle are present. Learned counsel appearing for the insurance company submits that in the earlier case, they could not, though they have taken a specific plea, as they could not reduce the evidence, the court in the said NVCs filed by the deceased and the injured has allowed the NVC, and again is that the appeal is also preferred as they could not adduce the evidence. They have withdrawn the said appeals. He submits that in this appeal, they have adduced evidence to show that as per the case sheet, the claimant was riding the vehicle who is a minor. In that case, insurance company is not liable to pay the compensation. He submits that a fraud has been played by the insurer against the insurer, and these kind of claims cannot be allowed. Then counsel appearing for the owner submits that the OD claim by the owner of the vehicle was already paid satisfied by the insurance company. He submits that as per the that I'll record yours is already satisfied by the insurance company. He has relying on exhibit PA discharge summary. He submits that in the owner of the vehicle. That in your submissions I'll reply to that. That he submits that in the discharge summary, it is clearly mentioned that he was traveling in a two-wheeler, and then counsel submits that even in the medical legal register, it is mentioned as he's traveling on the vehicle. It is submitted that it's a comprehensive policy, and they have spent a lot of amount, and the injury sustained by the claimant, who is a pillion rider, and the insurance company has to satisfy the same. In response to that, when counsel for the insurance company submits that the owner of the vehicle has not contested the case, has not appeared before the court below, Now, even in this appeal also, the counsel for the claimant has not, is not taking any steps. He has not taken, is not pursuing the matter as he has not appeared on the last occasion and on today. That itself shows that there is a collusion and it's a fraud claim is made. He submits that with regard to satisfying the OD claim and all, these submissions are made across the bench and no material is placed before the court. Yeah, it is submitted that the owner of the vehicle having played fraud on the insurance company, now having remained ex parte before the court below, cannot come before this court and contest the matter. Next para. This court, having heard the counsel for the respondent and having perused the entire material on the court. And having heard the land counsels have perused the entire material on the court. In this accident, two vehicles were involved. One is KA 41H 509 and KA 41J 9955. The present, the owner of the vehicle, the respondent herein is the owner of KA 41J 9955, and the claimant in this case is the son of the owner of the vehicle. And KA 41H 509 is the offending vehicle as per the claimants in this case. And the rider of the said KA 41H 509 has died on the spot, and the pillion rider has sustained injuries. Both of them have filed MBC 890 of 2009, the LRs of the rider, and the pillion rider have filed 890 of 2009, 891 of 2009, that is MBC. In those cases, there is a finding by the court that though it is claimed by the, though no plea was taken in the written statement, arguments were advanced by the insurance company that the minor son of the minor son that is a present claimant is riding the vehicle, and that as it is in violation of the terms and conditions of the policy, insurance company is not liable to pay the compensation. That was negative by the tribunal in those two two claims, stating that no evidence is adduced by the insurance company, and has dismissed the claims. Again, is that the appeals were filed, two appeals which have already taken. Two appeals were filed, and those two appeals were also were later dismissed as withdrawn. In this case, the court below, considering exhibit P20, the case sheet, and exhibit R2, has come to the conclusion that this is a fraudulent claim made by them, wherein in the case sheet it is shown that the son of the owner of the vehicle, that is the claimant, the appellant in this case, is driving the vehicle. Basing on the same, has dismissed the claim petition. This court has perused the discharge summary exhibit P8, which reveals that he was traveling I was traveling in a two-wheeler. And in the lower court record, this court found the medico-legal register. Even in that also, it is shown as that he was traveling in a two-wheeler. Learned counsel for the insurance company submits that the said document is not marked before the court below. Hence, the same shall not be considered. Now, in this case, exhibit P8 says something else, and exhibit P20 shows that he is riding the vehicle. In view of these discrepancies in exhibit P8 and P20, this court is not able to decide this issue. The court below, having considered exhibit P20, failed to consider exhibit P8. In that view of the matter, this court is of the considered opinion that this is a fit case to be remanded accordingly. The award dated so and so is set aside. Dated 14th day of August 2011 is set aside, and the matter is remanded back to the court below for fresh consideration. And the same shall be decided within a period of 2 months from the date of receipt of the copy of the order. Please take this. One, two. Who is in hospital? Counsel for the appellant or the respondent. When do you want? It is submitted by that there is some personal inconvenience to learn counsel for the appellant in the same caption, post next week.
Number 10,
10 days.
number 10, in Nagesh,
My lord, 9, my lord, what happened, my lord? 9 is
Any
not
call
called.
now.
No, I made a submission regarding that.
9 is not called.
It is already disposed of yesterday. By mistake, it is posted.
That's all. That's
Yes. Please argue. Your appeal is also there. Please argue. On quantum. What was the claim? Claim is 15 or 50? 33,04,400 is the claim. And how much is granted? 2 lakh? What are the injuries? Compensation to various. You find 2 fractures. And others are in simple in nature. How many are the others? Where is the wound certificate? Where is the description on that? Paragraph 15. Yes, please read. Give the record. Please read.
Another factor is based on data of which is number 228 dated 2009. So it's okay for Is defined as concerned to CT scan, and report injury number one, and the fracture of leg to
Look at the wound certificate. It just says others or how many or the injuries is not mentioned by the court. As for the wound certificate, according to the wound certificate, wound number 5 is only the grievous injury. As per the wound certificate, doctor's opinion is wound number 5 with reference to X-ray report is grievous in nature. Wound number 1 and 5. So he has sustained 1, 2, 3, 4, 5 injuries. 3 are simple and 3 simple injury. 17, para 17, let's see.
examined on the different side. It's stated that there is fracture of people of that. There is indication of the knee. There is also a report. There is fracture of waist mechanism. I do not find any substance in the evidence of PWC that there is fracture of lateral femoral that. The engagement also does not keep the same. It speaks about the fracture of fundal bone or the fracture of dislocation of metabolically bone of them. There are other simple injuries. As per the engagement, there is union of the fracture of that. Keeping in view the nature of injury, it is just a proper job.
That's a reasonable amount. How many months was considered as a laid up period? 2 fractures, at least 3 months is required. At the 5,000. Okay, you did. Impatient, but he cannot work immediately after coming out. It comes to 3,55,000. 3,55,000. That is pain and suffering, 1,10,000. Amount during the later period, 15,000. In the medical expenses, court has 1,10,000. That is 2 grievous injuries, 40 plus 40, 80, plus 3 simple injuries. 1,10,000. Medical expenses, court has granted 2 lakhs, that is maintained. And amount during the later period, court has granted only 5,000. This court is granting 5 into 3, 15,000. Loss of amenities, court below has granted 20, that the same is continued. And to our legal expenses, 10,000. It comes to 3,55,000. This is an appeal filed by the claimant, aggrieved by the award passed in MVC number 1075 of 2009, dated 3rd August 2011. The claim petition is filed seeking compensation of an amount of rupees 33,04,400 for the injuries sustained by the claimant in the accident that took place on 1/2/2009, while the petitioner was coming on his bike on Mysore-Bangalore highway at 180 full stop at 5:15 a.m. Near his village. A car driven by its the offending car driven by its driver in a rash and negligent manner hit his bike from backside. He has suffered grievous injuries. As per the wound certificate, he has suffered 2 grievous injuries and 3 simple injuries. After the accident, he was taken to the hospital. And was given treatment. He was inpatient for a period of 45 days. He has spent huge amounts towards treatment. Because of the injury sustained by him, he has suffered the disability. In support of his case, he has examined PW2. He has examined himself as PW1 and examined PW2 to 2 and 3, marked exhibit P1 to P17. On behalf of the respondents, none were examined. Exhibit R1 is marked. There is a Xerox copy of the policy. The court below, considering the wound certificate, has come to the conclusion that there are 2 grievous injuries and 3 simple injuries. The court has disbelieved the evidence of PW3, who has stated that the claimant has sustained disability on the ground that he has stated that there is a fracture of femoral condyle. There is 1 X-ray film of left knee and left foot dated 19/2009. And there is also a report in support of the same. And it is noted that no fracture concerned to right knee, and there is fracture of base metatarsal of left foot. Hence, the court has disbelieved the evidence, and the disability has as there is no fracture of left femoral, the court has disbelieved the evidence of the doctor on the disability sustained by the claimant. When it comes to the compensation, the court has held that for the pain and suffering, he is entitled for 25,000 towards medical treatment, basing on the exhibits marked on behalf of the claimant. Court has granted 2 lakh rupees. Towards loss of income during the later period, only an amount of rupees 5,000 was granted. Towards loss of immunity, 20,000. Altogether, an amount of rupees 2,50,000 was granted. This matter came up on 3/8/2003, and there was no representation on behalf of the claimant, and the matter is posted today for dismissal. Today also, there is no representation on behalf of the learned counsel for the claimant. Yesterday and today, the learned counsel for the respondent insurance company is present. As this is an appeal of 2001, this court is inclined to proceed on the merits of it. It is stated in support of in the grounds of appeal that the court below failed to consider that he was in hospital for 42 days and granting an amount of rupees 25,000 towards pain and suffering is fact. The court below ought to have considered the evidence of the doctor with regard to the disability and for the future medical expenses, conveyance and attendance charges. The amounts have to be enhanced. So where is the under that head? What is the amount? Nothing is granted. Medical transport and attendance. Will grant 15,000 under that. It becomes 3,70,000. If not granted any amounts towards so and so. Just now it is submitted that the amounts that it was stated that the amounts that are granted for loss of amenities is also not a reasonable amount. Then counsel appearing for the insurance company submits that the court below has rightly not considered the disability as the same is contrary to the medical evidence where there is no mention about sustaining a fracture to that there is a fracture of left femoral condyle as per the case sheet. He submits that as the claimants have not adduced any evidence, what is the amount that is, what is the income, what is the loss of income for the later periods, and further the amounts that were spent towards attendant transport and extra nourishment charges. The court below has rightly not granted any amount. This court has perused, having heard the learned counsel for the respondent insurance company, has perused the entire material on record. In this case, as per the wound certificate, he has sustained two fractures and 3 simple injuries. For that, he is entitled for an amount of rupees 1,10,000 towards pain and suffering. The court below has granted medical expenses of 2 lakhs, which is a reasonable amount. Coming to the disability, the court below rightly not believe the evidence of the doctor who has stated that as there is a fracture to the left femoral condyle, and because of that he has sustained disability. When the other material on record shows that and do not disclose that there is a fracture of left femoral condyle, and this court is also not inclined to consider the disability. During the later loss of income during the later period is concerned, according to him, he is earning an amount of rupees how much? 5,000, and the court has granted only 5,000. He was inpatient for 42 days, but the injuries sustained by him, at least he required 3 months time to work, and this court is inclined to grant 5 into 3, 15,000 for the loss of income during the later period. Loss of amenities, court below has granted 20,000, which this court is not inclined to interfere with. as the same as a reasonable amount towards medical transport and attendant charges. No amounts were granted for his 45 days of treatment in the hospital as inpatient. And for the fractures, considering these aspects, the court is inclined to grant 42 days. This court is inclined to grant 15,000 under the said head, and towards legal expenses 10,000 in the light, the next para, legal expenses in the light of law laid on so and so, 10,000 legal expenses. Altogether, the claimant is entitled for an amount of rupees 3,70,000. Accordingly, the appeal is allowed by enhancing the compensation from 2,50,000 to 3,70,000. Before. Yes.
Seven. CH-24.
Yeah. Number 11.
Number 11. CH-24.
Who will decide it by the court? There is a legal aid council's list. Is what is the notice of the court that land council for the appellant, Mr. Sridhar CK, is no more. As this is an appeal of 2012, issuing of notice to the claimant at this point of time may not serve the purpose. Hence, Srimati hence Srimati Geeta Mishra, the legal aid counsel, is appointed, appointed to argue this matter. And she is directed to serve the papers on her post this matter after 2 weeks, but in the name of this is so and so. Yes, next.
Number 12. On the table.
Support in all these cases, wherever the notices are not served, some endorsement is there. So bring the file located. What is that? What is that page? This item number 12. Notice to R1S. Difference with the white court order dated 17/8. Who is R1? Is the owner of the vehicle. Appeal against R2 is dismissed. By court order dated 17/8/2015. the court by order dated 17/8/2005, 15, as dismissed the appeal against insurance company. When the matter came up on 7th August 2023, as there is no representation, this matter is directed to be posted for dismissal today. Today also, there is no representation on behalf of the appellant. And the appeal is dismissed or not.
Nobody? Procedural. In-
Yeah. What was the claim before the court? Claim compensation? How much was awarded? 75,000 globally. You have not filed any appeal. Oh, your appeal is also there. What is then? What is who's a
Mistake was disposed of.
whose appeal?
So connecting my appeals.
Oh, that's where they are coming up again.
Disposed of.
Oh,
But it has been recalled.
yes. It is already been recalled. So 75,000 is the global compensation. So you are on the live, you say, you deny the liability also? Please come to the award. There are two MBCs. Which is the MBC in this case? MBC?
793.
1 minute. There are 1268, 1269. 1268. Yes. Let us go to the order and read the issue number 1, and from there you can make your submission.
Order. Page number 11.
Refer to paras.
Page number 11.
Para number 8. Please read para number 8.
Since observed that the accident was due to the rash and negligent riding of the motorcycle, its rider to 1 sustained multiple injuries. And the vehicle of the 2 also damaged.
You are a pillion rider. You are a pillion rider. Yes, please read.
I to her, this question is a billion rider. But as examination of the father, evidence of father,
No, let us read. Let us read.
figure 1 and 2 have sworn in their separate affidavit by way of their chief examinations, which are on par with the allegations made in their petitions for the occurrence of the accident due to the rash and negligent riding of the offending vehicle which leader. Same by 0-1. In support of the evidence, figure 1 and 2 got marked police notice exhibit P1, P2, and hospital information data, CMA report, the room certificate exhibit P6, further statement of complaint. Exhibit P7, spot sketch, exhibit P8, and spot mother, exhibit P9. The class examination directed to period 1 and 2 on behalf of the respondent to occurrence of the accident as well as the injuries by period 1 are not seriously disputed. Respondent 2 has got examined Dr. Shishikant and his official is not questioned. The appellate decision from the Miller. RW1 and RW2 respectively. RW1 is evidence spoken that is working as surgeon in Sanjeevani Hospital. It has published evidence that one injured Ashoka to treatment in the hospital. The exhibit R1 and R2 are got marked. Class examination directed it to not on record. There is no entry in the hospital. Got the effect that when Ashoka was riding the motorcycle attack at the accident. Very important. RW2 sworn to affidavit by way of chief examination, wherein he has stated that as per the hospital records related to the treatment of Ashoka, accident is shown to have occurred on 3 PM on 31/3/2009. So it has come to his students that according to the intimation issued by the Mangala Hospital, also accident is shown to have taken place on 3:30 PM on said date. Therefore, it is evident and audible to that there is a variation in the timings of the alleged accident as per the hospital records. And then the accident itself is doubtful. The class examination directed him. He admits that the police have submitted the charge sheet against the respondent 1 for said accident and further admits respondent 2 did not question the charge sheet before the competent authority. The learned counsel for the respondent 2 has also submitted his arguments.
Yes, I have seen the first issue. What are your submissions?
Third, he herself has read the vehicle. One Goda has been examined as 1 mile. In the class examination says that he is not the owner of the vehicle. My lord. Claim the compensation for damages in another case, my lord. The tribunal is awarded 5,000 for the damages. And when he is not in registered owner of the vehicle, he cannot claim compensation.
Yes, according to you, it's not entitled for the damages to the vehicle. Yes.
When he is not an RC owner, not entitled at all.
Yes, yes, next one. On the liability, you are saying, liability, how you are not liable?
My lord, whether he has claimed in his insurance company, is to prove that.
He has to?
His vehicle has also injured, has also damaged, and it has been insured by the New India Insurance Company. Whether he has claimed the damages, what he claimed, the New India Insurance Company, that document is not forthcoming.
So how is if he has not claimed for the damages,
He can claim here.
is it a ground that he cannot claim damages?
He can claim, but he should be the also owner.
That issue is you have already addressed.
Yes, yes.
So,
He can claim, no doubt.
yes.
But remaining, if they have not paid the amount, he has to substantiate that he has not received any amount from the own insurance company. That is most important, man. If they are not paid, or if they are not claimed there, then he has got a right to claim there.
No, he has filed a petition against the offending vehicle.
Yes, yes.
We are on
No,
that. Whether he has filed any claim for the damage to his vehicle from his,
Yes.
that is not the relevant factor
Yes.
for this case. Next.
Lord, the evidence of RW2.
Yes.
The complaint RP Manjunath has stated in the complaint that the petitioner Ashalata is elder brother's daughter. It's clearly shown that the petitioner complaint police and first responder proceeding together with inculcated one Ashoka as a pillion rider. The alleged accident. Their intention was to get unlawful flag by concealing the true material facts. And if he says that I was driving the vehicle, she has not produced the driving license report to the police. Substantiated that she has got a valid driving license, ride the motorcycle.
Let's not go to those kind of, please make some submission if they're relevant for this. No, there are two issues. One is liability and one is about the compensation. On the liability issue, there is evidence. Court has recorded about the timings and all. Those are not relevant because it is just 3:10 and 3:30 is not at all an issue. So coming to, and as you said, as he is not the owner of the vehicle, he cannot claim the damages to the vehicle. That will consider. Then coming to the compensation, according to you, how it is wrong. So how much compensation is granted? Please come to that issue.
Local compensation of 25,000 has been awarded.
No.
No doctor has not been examined.
Let us read that. Let us read that issue.
At page 9 of the judgment, my lord.
Yes.
The petitioner has asserted that she has spent ₹1 lakh towards her treatment. When her evidence has spoken to the applicant in support of her evidence, she got marked medical bills. Exhibit P10. Got disclosed that the petitioner has spent ₹12,940 towards her treatment. Medical bills produced by the petitioner are also not in serious dispute. Petitioner though asserted she has sustained permanent disability, partial disability, but she has not chosen to examine the doctor in support of the case. Therefore, considering the nature of injuries to the petitioner, as well as the amount spent towards treatment, some of the opinion must have experienced pain and agony, nourishment. She must have also spent towards attendant nursing extra and conveying charges. Further, petitioner is a woman. The injuries sustained by her may likely to impact the amenities of enjoyed their life. Where, as stated as Superintendent 1, spent rupees 12,840 towards the treatment in considering all global compensation of 75,000 has been awarded. Earlier, this matter was heard.
Now, how are you entitled for enhancement of compensation on what ground? The court bill has already granted to you the compensation without any best. At best, what can be done is both his appeal and your appeal has to be dismissed. When dismiss both the appeals. And as far as this 5,000 is concerned, how are you entitled? Are you the owner of the vehicle? No, damages to the vehicle. You are not the owner of the vehicle. Huh? Then what we'll do is, in his appeal, the amount that was granted is 75. 70,000 towards compensation and 5,000 to the damages. Altogether 75. We'll make 70. We'll make it 70. Or if you can make out any grounds, show the court for enhancement. Because you say that there are medical bills, you have produced the medical bills, you have not examined anyone, you have not examined the doctor, what are the injuries not known? Huh? There should be some certificate where the court will see all that. Court has already granted a good compensation. Will reduce at 5,000, 70,000 and your appeal will be dismissed. Please come. There's an appeal filed with both the insurance company as well as the claimants have preferred the present appeal. I preferred the appeals agreed by the award passed in MDC number 1269 of 2009 dated 1st August 2012. The appeal of the insurance company is listed is numbered as MFA number 793. 93 of 2013 and the claimant's appeal is MFA number 11324 of 2012. The claim petition is filed seeking compensation of an amount of rupees 20 lakhs for the injuries sustained by the claimant in the accident. The court below has awarded a global compensation of 75, that is 70,000 compensation of 75. No, 5,000 is extra. No, that this is
75,000 may not. Order.
please wait.
12 may not. In MBC 1268 is entitled for account 75,000 %.
Not mentioned 5,000.
Yours is MBC number
68.
12. Then damages is granted.
They are not filed any amount.
You are
Yes,
arguing that when he is not the claimant, why should you argue? That is in 1269 to the owner of the vehicle only it is granted. This is an appeal filed by the claimant agreed by the award passed in MBC number 1268 of 2009 dated so and so. I have given the date, no? So and so. What did you write before this? Huh? All of you stand here so that it will be clear to me. Yes.
NVC number 1269 of 2009,
1268,
dated 1st August 2000.
2005.
The appeal is of the insurance company is numbered as MFA number 790 of 2013, and the claimant's appeal is 11324 of 2012. The claim petition is filed seeking compensation of amount of rupees so
Global amount, granting global compensation of an amount of rupees 75,000 to the claimant. Land counsel for the, it is a case of the claimant that is proceeding on the vehicle as a pillion rider. On 31/3/2009, when the motorcycle reached near Syndicate Bank, Salagrama Road, at the time a motorcycle being driven by its rider in a rash and negligent manner, dashed against the motorcycle and to the same. They have sustained blunt injuries and admitted in the hospital. The scooter was also damaged in the said accident. Submitted that the claimant has incurred huge amounts for the injuries sustained by her. The court below on issue number 1 has said that though it is contended by the insurance company that as per the rider of the motorcycle, the accident has taken place at 3:10. As per the pillion rider, it is at 3:30. And regarding the other evidence on record, the court has held that the accident has taken place because of the rash and negligent driving of the driver of the offending vehicle, which is insured with the respondent insurance company. And the owner of the vehicle as well as the insurance company are jointly and severally liable to pay the compensation. The court has also observed that the documents produced by the claimant and the evidence of PW 1 and 2 flinchingly established that the accident was because of the rash and negligent driving of the driver of the offending vehicle. When it comes to the compensation, the court has observed that yes, according to the claimant, she has spent an amount of rupees 1 lakh towards treatment and some more rupees 12,940 towards medicines, which are not disputed by the insurance company. The court, and it is also the case with the claimant that she has sustained disability, but she has failed to examine the doctor. Considering the injury sustained by her, though there was no evidence of the doctor with regard to the disability, the court has granted a global compensation of 75,000, including the medical expenses. Then counsel appearing for the insurance company submits that as there was discrepancy in the evidence of the claimants, that is the rider and the pillion rider, about the time of the accident as 3:10 and 3:30. The court below ought to have believed the evidence and ought not to have granted the compensation. We submitted that as the claimant failed to examine the doctor, the claimant is not entitled for any compensation. And the court below, without considering all these aspects, has granted the compensation. Then counsel appearing for the claimant submits that there is no dispute about the fact that the accident has happened, and the court below, having given a categorical finding on that, ought to have granted the compensation as claimed, as he has spent a sum of rupees 1 lakh towards the treatment and other expenses towards transport, extra nourishment, and attendant charges. He submits that the court below, without considering all these aspects, has granted the compensation. The court has perused the entire material on record. The main contention of the learned counsel for the insurance company is about the discrepancy with regard to the time of the accident, that is 3:10 and 3:30. The court below has rightly disregarded the said contentions and held that it would not make any, it would not go to the root of the issue, or it will have, or basing on that, the evidence of the claimants cannot be discarded. Except that the other evidence of the both documentary as well as the oral evidence on behalf of the claimant. Suppose a case of the claimants that accident has happened because of the rash and negligent driving of the driver with the offending vehicle. And you have the same, this court is not inclined to interfere with the said finding given by the tribunal. Then coming to the compensation, the court below considering the injury sustained by the petitioner, and as he has not examined the doctor, has not considered the disability and other aspects, and granted a global compensation of 75,000, considering exhibits P6, P10, exhibit P6. In the considered opinion of this court, the court below is right in granting the said compensation. Both the insurance company as well as the claimants have, both the insurance company as well as the claimant have not made out any ground seeking interference of this court. Accordingly, both the appeal of the insurance company as well the claimant are dismissed. Next. Then what about this 13.2? This next matter, 1007. He's the owner of the vehicle. No, really. Starting itself, you have to say that the insurance company has filed MFA number in the starting 1007 of 2013. Again, in questioning the award in 1269 of 1269 of so and so. MVC number 1269 of, let's look at the year 1269 of so and so, where 5,000 amount is granted to the owner of the vehicle for the damages to the said vehicle. The grounds that are raised, the insurance company could not make out any grounds finding could not make out any grounds or any irregularity in the order passed by the tribunal. Accordingly, the appeal is also dismissed. Yes, next.
I appeal for the second respondent. Petition was dismissed before the tribunal.
When did you give an objection? No, you.
If I sent it to their place, Saturday, I sent it to along with the entire.
So it is submitted by the council that he has given up wakalat in this matter. Finally, pose this matter next week. Finally, pose this matter after 10 days. If there is no representation on that day, the matter will be heard on merits. Learn also the respondent present. Serial number 13.2. Any amount that is deposited by the insurance company shall be forthwith transmitted to the court below. Yes, next. Appellate. Your Savannah order. It's a case of enhancement of compensation. How much was claimed? 25 lakhs. How much was granted?
7,62,080.
60?
62,000.
800.
80.
80. is it a case of, is there any disability?
Statement 26% after scale, it was taken.
There is no appeal of yours. So please come to the issue number 2.
Eight second being committed fracture of left femorial shaft and leg fracture of left. After
No, your age is
20.
30 years and your income,
10,000.
court has taken 6,000. And self-employed agriculture and was earning rupees for 10,000 per month. Any documents to prove his said income? Now, what do you say on this? We'll take 6,000 because there is no evidence.
Yes.
Huh?
Yes and no.
There should be some evidence on record. 6,000 will take, or court has rightly taken. Yes, then coming to the injuries.
Eight second being committed fracture. Left femorial shaft of cadent fracture. Clavicle left fracture of hips.
So how many injuries? Three fractures. Yeah. $30,000 was also reasonable. Loss of income.
Loss of future medical expense.
During laid up period.
Even for medical.
1,20,000 will grant. Yes, next, medical expenses. 2,86,000. That is also 86 to 80. 1 minute. Let's go one night after the other. Then loss of future earnings. Capacity. 6,000 into 12 into 50 into 26 by 100, perfect. Loss of amenities, 35,000. They should prepare an appeal. Conveyance, on that also good amount.
It's also granted.
Future medical expenses, yes. What was the evidence of the doctor? Hmm? Where did he say? Para? No. No, what evidence of the doctor? Why are you saying that this amount is lesser? What did the doctor say? According to the doctor, how much is required? 25,000 is not at all a less amount.
It's in 2012. After
No,
lapse
they
of
should-
11 years,
he says that man he has to undergo operation in future. After lapse of 11 years, so far they have not undergone. And in spite of that, man, 25,000 is already granted.
Now, if we add another 45,000 to this, it is what was granted is 1 lakh, 7 lakh, 62,000. 7 lakh 63,000 080. Legal expenses. Comes to 8 lakh 17,000 080. So, there is an appeal filed by the claimant, agreed by the award party. NVC number 6040 of 2012, dated the 3rd July 2014. The case of the claimant is that on 5/7/2012 at about 5:20 p.m., when he was proceeding on a motorcycle near Hinekki village, Surya City, second stage, sector 4, road junction, Anekal Taluk. At that time, the driver of the swift car had come at high speed and in a rash and negligent manner dashed against a motorcycle, due to which had fallen down and sustained grievous injuries. According to the claimant, he was aged about 40 years as on the date of an accident and was earning an amount of rupees 10,000 per month. He has also sustained 3 fractures, and because of the said fractures, he has sustained a disability of 26% to the whole body. The court below, as there is no evidence in support of his income, has taken 6,000 per month, and towards pain and suffering, granted an amount of rupees 75,000, and towards the loss of earning during the medical treatment during the read-up period, has granted an amount of rupees 30,000. The medical expenses, basing on the evidence, an amount of 2,86,280 was granted. And because of the loss of earning, future earning, because of the disability, taking 6,000 and the 26% disability as deposed by the doctor, has granted an amount of rupees 2,80,800. Towards loss of amenities, rupees 35,000. Conveyance, transportation and attendant charges, 30,000. Future medical expenses, 25,000. Altogether an amount of rupees 7,62,080 was granted by the court below. Then counsel appearing for the claimant submits that his income is 10,000 and court below has taken, you're working as a mason or plumber? Working as a mason and earning an amount of rupees 6,000, 10,000, and the court below has taken only an amount of rupees 6,000. It is submitted that when he has sustained 3 previous injuries, but under the head of pain and suffering, only an amount of rupees 75,000 was granted by the tribunal. He submitted that towards the future operation, the granting of an amount of towards a future operation, the medical expenses, granting an amount of rupees 25,000 is on the lower side. It is submitted that the tribunal ought to have granted a reasonable compensation. When counsel appearing to the insurance company submits that the court below, considering the evidence on record and has already granted a just and a reasonable compensation, and no grounds are made out to seeking interference of this court. Having heard learned counsels on either side, this court has perused the material on record. As rightly pointed out by learned counsel for the respondent, the court under the head of loss of income during the later period, medical expenses, loss of future earnings due to disability, loss of amenities, conveyance, extra nourishment and attendant, and future medical expenses has granted a reasonable amount, and on this count, there is no interference is required with the findings of the court below. However, on the pain and suffering, as he has sustained 3 factors, and court has granted only 75,000, the considered opinion of this court is entitled for an amount of rupees 1,20,000 and 20,000. Full stop. Next para. In the light of the law laid down by the apex court in Mekhala versus so and so, the petitioner the claimant is entitled for an amount of rupees 10,000 towards legal expenses. Altogether, it comes to 8,17,080. Accordingly, the appeal of the claimant is allowed by enhancing the compensation from 7,62,080 rupees to 8,17,080 rupees. It is submitted by the counsel for the insurance company that they have already satisfied the award, the enhanced amount from the deposit within a period of 4 weeks from the date on which is the copy of the order. The enhanced amount will carry 6% interest. But you asked me that we have a
With the otherwise they will be.
as far as the future medical expenses are concerned, the court below has already held that it will not fetch any interest. Accordingly, it remains to be the same. Yes, next. The number 16. Yes. I've asked the registry to do it. As there is no representation on behalf of the land council for the appellant. You are for the respondent. The registry is directed to issue the set of papers in the appeal to the land council for the respondent. Respondent number 1. Yes, next.
1700, page number 80.
What is the application? They filed a petition.
Kannada Daily, Kannada edition.
This is the application. I one of 2023 is filed for taking substituted service on respondent number. Respondent number 1. Respondent number 1, as appellant has failed to serve notice on the respondent. Hence, this application is allowed, directing the petitioner to take out notice advertisement in Kannada daily newspaper, Hosa, Diganta mentioning the date.
Yes.
Yes, yes, please.
Serial number 19 adjourned, serial number 20. Aligola.
Total applications. It's coming up for. Where are the councils?
Serial number 20.
There is no representation on, in both the appeals. Post these appeals for dismissal tomorrow.
Serial number 21 adjourned. Serial number 22. O Mahesh.
Yes, Mr. Mahesh. 20, not 20. 20 is posted for dismissal. We appear for that.
21. 20.
You 20.
In 21, I represent second respondent.
1 minute. If nobody is 20 calls.
21 has already adjourned in the morning.
21, somebody has made a mention in the morning.
Serial number 20.
Yes. There is a, you are for the insurance company? Or payment, insurance company appeal is also there. You appear? Yes. Argue.
I appeal merit seeking enactment of compulsory.
How much was claimed?
Particular
How much was awarded?
10 lakhs.
Case of injury?
Case of
Any disability?
disability
How much was taken by the court? So on what ground you are, on what ground you are entitled for enhancement?
the nature of injuries, but appellant has sustained a fracture of both bones of tibia.
Let us see the issue number 2. You are on liability or quantum? Yes. Please come to the discussion. There are no issues. The court is right away come to some reasons. Come to para 11. Cut wound.
Please.
Read.
Cut wound of 3 to 4 centimeter over the
So 2 simple injuries and 2 fracture injuries, grievous injuries.
both leg.
Fracture of both tibia and fibula of right leg. Fracture of both tibia and fibula of left leg.
How much is granted with the tribunal under the head of pain and suffering?
Pain and suffering may not 95%. In page 12 of judgment, there are 29 mirrored break up in pay.
No, we'll read.
In the medical treatment, mirrored 2 lakhs, medical bills to mirrored 2,75,000 awarded. Incidental charges mirrored 25,000.
No, we'll go by one head and the other. So as far as second is concerned, 2,75,000 is awarded. Are you entitled for any enhancement?
No.
What about you? So what? Yes.
In my view, it cannot be possible to produce the bills and vouchers for having spent on internal expenses. Petitioner has produced medical bills explicitly worth 2,36,005. The petitioner has not produced the bills and vouchers. The evidence based on record reveals that the petitioner suffered fracture to both bones of both legs. The petitioner cannot walk for long time, and he walks facility with the help of walking tools. There is a deformity and tenderness present on both legs. He cannot ride the bicycle. He cannot squat on. He cannot use Indian talent. The fractures are non-limited.
So for how much amount there have been?
2,36,700.
For that bills are there?
They were granted 2,75,000.
Yes. Next,
25,000 rupees is granted towards conveyance in incidental.
that is reasonable.
When, my lord, rent as inpatient for a period of 40 days. And, granted,
Transport, no, transport and nourishment. 25,000. And for both the attendant charges will grant another 10,000. Yes. Next.
Period of period, my lord,
That's why we'll come after. Next, come to para 17. Let's come to para 17. Anyhow, till 20 it is dealt with because for pain and suffering court has already awarded 1 lakh. So come to next.
Only 75,000 has been.
This court is awarding 1 lakh. That is done. Come to the next one. Loss of income 21. How you are, according to you, what is your income?
Income, my lord, 10,000 per month. 10,000 per month, my lord. Notional income may be considered. But accident, my lord, date of accident is 28/6/2010. But tribunal considered, my lord, only 4,500.
Perfectly considered.
4,500.
We'll take 4,500 only. No, and once it is 4,500 is taken, then there is nothing to, and you are on disability, you are disputing? Where is evidence of doctor?
Age is 35 years.
Multiplier 16.
16.
According to the chart prepared by the legal service.
That chart, that especially is over in the court the other day. That the court is not, and it seems that the revision bench also said that it will not be, shouldn't be applied. It's only for settlement for the Lok Adalat, not in a judicial proceeding. Yes.
Paragraph 23.
Paragraph 20. No, that 4,500 is not it.
Medical officer credibility is equal that the patient has suffered permanent physical disability of 55% of the particular part of the body. Disability is the disability. The assessment of damages in case of personal injuries must be made on the basis as to what is the resultant impact and the effect on the earnings or capacity to work. It is not entirely right to always make the future loss of coexistence with the field of personal permanent disability. It is not an algebraic or mathematical formula which can be applied anywhere regardless of the application or profession of the injured planet. It is a problem which has to be approached from point of view. What is the resultant effect on the actual earnings or on the earning capacity? In the view, the determination of loss of earning capacity has to be reference to all the work which the person was capable of.
The court has assessed it at 50% and accordingly granted 4,32,000. What is your submission on that? He himself has stated the doctor. Where are you reading?
Ground number E at
Not your grounder. From the judgment, you tell the court. So how excess? The doctor now he said to a particular limb, not to the whole body. Why the court has taken to the whole body? The evidence of the doctor is 50% is to a particular part of the body, not to the whole body.
Give the evidence of.
Give the record. Or court record. Let us see his evidence. What has been exacted by the court is that it is to the whole body. In that case, 50% can't be taken. This history of articles of the first one. It's in English? The evidence of doctor is in English? Oh, what did he say in cross-examination? And what was his evidence in the chief? What evidence where is it? Did he three? He got PWT and send the lower court record. There should be a, if there is an index there, should be easy. Just like that, they're dumping the paper. It doesn't contain the numbers. Thank you. Please give it to him. Please. Yes. So there is a non-united fracture of both bones of both the legs. He is an agriculturist. So he didn't say that to the limb, but to the body, he said. Okay. You know, what will happen is, that's a basic, when his both legs are impaired, he can't even walk, he's an agriculturist. In fact, if you have to look at it, he can't work at all now. We'll take agitate. So, that is, the court has granted 4,32,000. Loss of income due to disability.
Loss of expectation in life and loss of amenities is 75,000 rupees is there. Towards loss of family life 1,10,000.
Considered only 2,000 loss of income. No, his income is taken as 4,500. So loss of income during the later period. Later period will take 5 months because of the kind of injury sustained by him. 4,500 into 5. 22,500. So that will come to that. That amount will make 50,000. We'll reduce it. It is a 1,10,000. We'll make it 50,000. Where?
Loss of expectation in life and loss of amenities in life and loss of comfort.
Where is that? Which is
29th page.
29. Loss of family life 110. And where you get the amenities? 75,000. And by the both the counts you are not entitled.
Regarding communities, my lord, looking into the nature of injuries, my lord, Tribunal has granted just and reasonable compensation.
So you have been granted for the earning capacity, pain and suffering, amenities, loss of marital life. How many counts you will have? So what we will do is loss of family life, no amount will be granted. Under this loss of amenities, the court has granted an amount of 75,000. That will make 1 lakh. And legal expenses 10,000.
It's what's the.
The legal expenses means not about filing of the court case. It is about in that judgment Supreme Court has considered about engaging of the advocate and all. In that regard, court has considered it in Makela's case. It come to 9,36,205. We'll litigate after lunch. Continue.
Number 20, Nandya Gowda.
With your lordship's kind leave, my lord, one submission, my lord, one matter for tomorrow or day after tomorrow. I got.
But how can you make a mention at 1:30?
I'm sorry, I was busy in portal number.
Or give the slip to the court officer, any matter will come.
Yes, please.
Court has no
Serial
objection to
serial
this
number
matter.
32, my lord. Serial number 32. Tomorrow or day after tomorrow, any day I am ready.
Tomorrow.
Much
Inform the
obliged.
other side.
I'll inform, my lord.
No, problem is you have to inform and then take.
Right now I'll inform. Right now I'll inform.
Tomorrow, close the matter tomorrow.
Much obliged.
And I request all the advocates not to make any mentions in the afternoon.
I'm sorry, my lord. Sorry for the inconvenience.
Yes, there's an appeal agreed by the award person. MFA number, MBC number 1110 or 2010, dated 7th March 2012. Both the insurance company as well as the claimants have preferred the appeals before this court. The appeal of the claimant is numbered as MFA 9226 and the insurance company as MFA number 5863 of 2012. The claim petition is filed seeking compensation of an amount of rupees 25 lakhs for the injuries sustained by the claimant in the accident that took place on 28/6/2010. The tribunal has granted an amount of rupees 10 lakhs and considered the disability at 50%. As for the claimant, he was 35 years old, doing agriculture work and earning an amount of rupees 10,000. While he was proceeding on a motorcycle on 28/6/2010, when he came near Chikkabenur village, Chitradurga Taluk, about 3:30 p.m., the driver of the Bolero pickup vehicle drove the vehicle in a rash and negligent manner, dashed the motorcycle and caused the accident. In the said accident, as per Exhibit P5 wound certificate, he has sustained cut wound of 3 into 4 centimeters over the right leg, cut wound of 2 into 5 centimeters over the left leg. Here. And a fracture of both tibia and fibula on right side, fracture of both tibia and fibula on left side. The doctor gave evidence. Where is he? As per the doctor, that is PW2. Who deposed that because of the injuries sustained by him, those fractures which are malunited, the petitioner cannot, the claimant cannot squat on the ground, he cannot use Indian toilet, he cannot walk long distance, he cannot ride the motorcycle. And in the evidence, I think he said that he is walking with the stick and also is walking with the stick. Basing on under, he sustained 55% disability. Court has considered 50% disability, and there was no evidence to show that the claimant is earning 5,000 rupees. Court has taken 4,500, and by applying, as his age is 38. What is the age? 34 or 38? Age of 35 years, applying the multiplier 16 has granted the compensation under the head of loss of income due to disability at 4,32,000. The petitioner, the claimant, has produced the bills, medical bills, for an amount of rupees 2,36,705. And for the remaining amount, no bills were produced, but the court has considered, has granted an amount of rupees 2,75,000. And towards the pain and suffering, an amount of rupees 75,000 was granted for the two grievous injuries and the two simple injuries. And towards future, towards loss of family life, an amount of rupees 1,10,000 was granted. And an amount of rupees 8,000 towards loss of income during the period of hospitalization and bed rest. And towards loss of amenities in life, an amount of rupees 75,000 is granted. Land counsel appearing for the insurance company submits that when it is a case of the claimant that when the claimant has produced before the court the bills for an amount of rupees 2,36,705, the court below ought not to have granted an amount of rupees 2,75,000 without any basis. He submits that when the court has granted an amount of rupees 75,000 towards loss of amenities in line, court below ought not to have granted another amount of rupees 1,10,000 towards loss of family life. Further, under the head of pain and suffering, already an amount of rupees 75,000 is granted by the tribunal. It is submitted that even on the disability also, taking disability at 55%, 50% is on the higher side. The tribunal ought not to have taken the disability at 50%. It is submitted that any other ground? Then counsel appearing for the claimant submits that the court below ought to have taken 55% as a disability. During the later period, as it takes minimum 5 months for him, at least to come to normalcy with the injuries sustained by him, the court below ought to have granted a reasonable amount. He submits that under the head of pain and suffering, the court has granted only an amount of 75,000, which is not a reasonable compensation. It is submitted that towards the medical bills, court below has rightly considered the incidental expenses and granted an amount of 2,75,000. He submits that as it will have a impact on his family life, the court has granted 1,10,000. Land counsel submits that the court below ought to have taken the income as 10,000, but has only taken 4,500, which is on a lesser side. It is submitted that the compensation that was granted by the tribunal was not a just and reasonable compensation. Having heard land counsels on either side, the court has perused the entire material on record. As per the wound certificate, the claimant has sustained 2 simple injuries and 2 fractures. On that count, he is entitled for an amount of rupees 1 lakh under the head of pain and suffering. Then coming to the medical bills, the court has observed that the bills were produced for an amount of 2,36,705, but the court has granted 2,75,000 without any basis. Hence, the petition is only entitled for an amount of 2,36,705 towards medical bills. Under the head of in his contentions, transport towards attendant benefits, as it has took a lot of time for him to recover, granting an amount of 25,000 for transport and extra nourishment is bad. The contention of the land council that towards transport, extra nourishment, attendant, 25,000, an amount of 25,000 granted by the tribunal is not a reasonable compensation. For the two, as there is fracture in the 2 legs, in both the legs, and as they are malunited, it requires a constant attendance. And the tribunal granting only an amount of 25,000 is not reasonable. So under the head of attendant, he is entitled for another 10,000, apart from the 25,000 granted, towards loss of income due to disability, when there was no evidence on record to show that he is earning 10,000 rupees. Court has rightly taken 4,500. And by applying the multiplier 16 and rightly taking into consideration 50% as a disability, has granted an amount of rupees 4,32,000, which is a reasonable compensation, and no interference is called for. Then loss of income during later period, as it takes minimum 5 months for him even to attain normalcy, 4,500 into 5, 22,500 would be the appropriate amount as law under the head of loss of income during the later period. When coming to the loss of family life and loss of amenities, he is not entitled for amounts on both the counts, where the court has granted 1,50,000 altogether, lost 1,75,000 on both the counts. 1,85,000. No. One is 1,85,000 was granted. The claimant cannot be, is not entitled for such a huge amount under the two heads. Hence, under the head of loss of amenities, as a court below has granted only 75,000. This court is inclined to grant 1,000, but is not entitled under the head of loss of family life. Towards legal expenses, 10,000 or judgment. Altogether is entitled for an amount of rupees 9,36,205. Accordingly, the appeal of the claimant is dismissed. The appeal of the insurance company is partly allowed, reducing the compensation from 10 lakhs to 9,36,205. The enhanced amount will carry 6% interest, and the registry shall transmit the statutory deposit made by the insurance company forthwith to the court below. Yes, next. Yes, Mr. Mahesh.
This is regarding, my lord, the driving license. The Mukund Devagan case, my lord, is posted on 13th of November. It may kindly, my lord.
The council submits that the issue in this case is with regard to the driving license, and the Mukul Devagan's case is pending before the larger bench, and that is coming up on 13th. Post this matter on 19th, which is the date, 19th.
Please.
Final hearing, serial number 24. Is it back?
1 minute. Yes. How much is the claimed amount? How much you claim? Please come to that finding. No, before that, let us understand what is the case. Okay, the definite case of the petitioner that on 27/11/2007. Come to para number 10. I think this case was heard This was heard earlier. Why is it adjourned? Police did. No. No, you said there is something that you want to place.
Only two witnesses are produced. There are one claimant and another doctor who represented claimant. Actually, speak more matter. What murder? Due to the national negligence crime of the respondent.
However, he admitted that he was charge sheeted in CC number so and so and pays the trial. That is you, claimant.
The charge was filed against him. And the alternative was their own colleagues and they have filed a record against me and charged it against me.
So at least what is the independent evidence you have let in this? Then what to do?
Okay, I can say that exhibit video.
What it shows? Mahajan will not show you who is responsible for the accident.
The basic was holding the downside. The CD has been given yet. Let's speak about agencies of the claim. Police vehicle was found in the wrong side of the road. The claimant vehicle.
Pass on. Pass on. It is carrying the whole thing.
They may be given paragraph 50. Putting the football to ban in here. The vehicle was found on the left side. Person was on the right side.
Both of them were on the left side.
Bike was specifically to mining. Sir, it's in the left side only. It's correct.
No, a vehicle is coming from the opposite direction. So even if you hit the vehicle also, it has to go to the other direction, not to this. That's what you're saying? Then appeal filed with the payment. Agrees with the award parcel. Commission number 1422 of 2008, dated 28 September 2011. The claim petition is by seeking compensation of an amount of rupees 7 lakh with rate of 18% per annum. The case of the claimant is that on 27/11/2007, he was proceeding from Puttur towards PC Road on his Bajaj Pulsar motorcycle, slowly by following the traffic rules. When he was proceeding near a place called Patlakoti of Mani village, a jeep driven by the respondent number 1 in a high speed with rash and negligent manner came from opposite direction and dashed the motorcycle of the petitioner. In the result, petitioner fell on the road and suffered with grievous head injuries, other injuries to the parts of the body. He was taken to the hospital. He took treatment as an inpatient for about 19 days from 28/11/2007 till 16/12/2007. He took bed rest for about 6 months and follow-up treatment as per the advice of the doctor. The court below has dismissed the application or the claim petition filed by the claimant on the ground that in respect to the said accident, crime is registered against the petitioner claimant and a charge sheet was also filed. When an application is filed under 166, the burden lies on the claimant to prove the claim, to prove that there is rash and negligent driving on the part of the driver of the offending vehicle, as he has failed to prove the same by adducing any independent evidence. And as there is no evidence on records, court below has dismissed the petition. Land counsel for the petitioner submits that he was going on a right direction, and as it is a police vehicle, charge sheet is filed against him, and he submits that he has been implicated in the case, and the charge sheet is filed against him. However, it does not dispute the fact that no independent witness was examined, no eyewitness was examined, and no other material is there placed on record to show the negligence on the part of the driver of the offending vehicle. In that view of the matter, its court finds no reasons to interfere. Accordingly dismissed. Author of which document? Right. No, that's not sufficient. Person who has given it should be examined. How much is rent? How much you claim? Yes, sister. That is true, but to ascertain the damages, you have to adduce the evidence, and the court cannot, basing on your affidavit or the claim petition, cannot grant. Might be, and what is the? What do you say? What do you say? As per the IMV report, there is a damage. So, if not what the amount he is claiming, why not some reasonable amount, some guesswork? On that ground, it dismissed. That's not mentioned in the petition.
Not claimed any amount by.
Where did you say? That's in English. Take that. You get the space. It is not true to say that I have claimed vehicle damage compensation from the insurance company. I have not produced any document to show that I have not claimed vehicle damage compensation before the concerned insurance company. Huh? No, if he has not claimed, what he should produce?
NCB, very clear.
That he should have filed. Please come. In an appeal filed by the claimant agreed with the disposal of MVC number 7959 of 2010. A claim petition is filed seeking compensation for an amount of rupees 4 lakhs for the damages caused to the Tata Ace in the road traffic accident. The case of the claimant is that on 25/8/2010, about 4 a.m., the petitioner was driving his Tata Ace where from Nela Mangala towards Kurigal carefully and cautiously. At the time, a canter stopped the vehicle without giving any signal in a rash and negligent manner, without observing the traffic rules, and due to the said impact, and dashed against the canter. Due to the impact, the petitioner's vehicle was totally damaged. He got his car repaired and spent 80,000 towards repair charges, 50,000 towards conveyance and other charges, and claimed the compensation. The court below has dismissed the petition on the ground that the petitioner has not examined anyone in support of the bills that are marked before the court below. That is Exhibit P6 to a tune of rupees 37,670. Then counsel appearing for the claimant submits that the court below ought to have considered the IMV report. As per the same, there is a damage to the vehicle, and on that basis ought to have granted the compensation. Then counsel appearing for the insurance company submits that whether the petitioner has claimed from his insurer the damages to the vehicle are not known, and he has not stated anywhere in the claim petition. In the absence of any evidence, he is not entitled for the compensation. In response to the same, then counsel for the respondents of claimant submits that in the evidence, in the cross-examination, a question is put to him whether he has claimed the compensation for the damages, which he has denied the same, which he has denied. Next part. When it is a case of the claimant that he has the vehicle is damaged, he has spent huge amounts for repairs, he should adduce some evidence before the court, and basing on that evidence, court will decide the compensation. In this case, we will accept marking the bills and an assertion that he has spent amounts He has not examined anyone. Merely basing on the IMB report, the court cannot grant damages to the vehicle. For the, under the head of damages to the vehicle, that we have the mark of the court below has been. Accordingly, appeal is dismissed. Yes. Who appear for the respondent? You are there? Yes.
Date of accident is 8/3/2010 at about 8:45 a.m.
Before that, what is the claimed amount? Claimed amount.
4 lakhs.
How much was granted? Dismissed. We'll go to that issue.
The plan taken by the respondent. One of the appellant. The discrepancy is different. The medical records, it is shown as a tractor. The claim petition, also the police record, it is a two-way.
It is shown as
Two, white.
two-wheeler.
Therefore, yes, there is a discrepancy. I go by the medical records. If you are a tractor, you are not considered as a tractor, you are proceeding against the bike. Therefore, I reject the cancellation. That is the gist of the matter. So, Lakshman kindly appreciate the stand taken by the respondents. Owner of the two-wheeler, insurer of the two-wheeler. That is at paragraph 3. Paragraph 1 and 2, my case is set out. Paragraph 3, the first respondent has appeared before this tribunal, through its counsel and has filed written statement and contending that the petition is not tenable under law. This respondent has admitted issuance of insurance policy to the offending vehicle. Offending vehicle in this case is two-wheeler. As on date of accident, subject to terms and conditions mentioned there. Owner has violated insurance policy conditions. Therefore, this respondent is not liable to pay compensation. This respondent has denied use of the person income of the maker of the system. Age and period of payment and the compensation. The accident has occurred. Up to vehicles. The owner and insurer of the petitioner's vehicle are proper and necessary parties. The compensation amount claimed in the petition is exaggerated and excessive. The offending vehicle is not at all involved in this accident. It is paid that the petition to be dismissed as cost. This is the insurance company. Then the owner of the two-wheeler. The second respondent has appeared before this tribunal through its counsel and filed a written statement pretending that the petition is false fixations. This respondent has denied column number 3, 4, 6, 8, 11, and 14 of claim petition as false and incorrect. Compensation amount claim is fanciful and whimsical. The entire story of accident mentioned in column number 20 of the petition is first respondent and the insurance policy. Therefore, this respondent is not liable to pay compensation. It is paid that the petition is to be dismissed as cost. This is the owner of the two-wheeler. He could have said, my vehicle is not at all involved. There is no such buildings at all. Then we go to trial. Then the following issues are taken. First issue is whether the petitioner proves that he has sustained injuries in a motor vehicle accident that was taken on 8/3/2010 at about 8:45 a.m. Here, Karnataka village, Satnur Road, Report acted negligent riding of vehicle bearing number A03TC110 by its rider involved in this business incident. The petitioner, one doctor and two witnesses are examined as PW1 to PW4 and got marked exhibits P1 to P15. The legal manager of insurance company is examined as RW1 and got marked exhibit R2. Third arguments on both sides and the records the following findings are affected issues. First is negative. because of that, the tractor reasons. Petitioner himself is examined as CW1 who has deposed and reiterated petition government in detail to a degree of examination in chief to affidavit as provided by law. CW1 has further deposed that on 8/3/2010 at about 8:45 AM, petitioner was proceeding on motor cycle number parent 05 HA8357 on Handur Road, near Tank Bund as a pillion rider. The petitioner's son, Shiv Madhav, was riding said motor vehicle.
So, when accident is on 8/3/2010, when was the complaint given?
9/3, that's 5:30. In the evening,
8/3/2010, time of the accident,
8/3
time.
is late in the morning, 8:45. AM.
And you have given complaint on 9/3/2010 at
Evening. Sun has been. Because I was
at night,
5:30.
5:30. And as per the FIR, what did you say?
FIR has said two-wheeler only.
Two-wheeler.
Two. Charge sheet is also filed against. They have not contested the
Oh, let us see the exhibits.
exhibit.
Who is PW3?
PW3 is an eyewitness. PW4 is also an eyewitness.
No, they just now I read somewhere that PW3 said the claimant's son has asked me to come and give evidence. P1 is a FIR.
PW3 is a doctor.
Somalia, 2 copy of Panchnama. 9/3 was a Caesar Panchnama.
PW4 has been filed.
2 copy of certificate.
And before the order, that's on the request of witness.
Is the record? In the cross-examination to PW1, not even a single citation is given saying that the vehicle involved is not the two-wheeler but a tractor. Look at the evidence of PW1. Not even one suggestion. You have the evidence? Just look at the cross-examination. Not even one suggestion. No, at least in the cross-examination, what did they do?
Over the vehicle on which he was going is Victor. The doctor must have taken it as a tractor.
What is that?
The bike on which he was traveling. The Victor. He must have said Victor. Was traveling Victor. Doctor might have taken a reference to it as a tractor. That might be the reason. And they have conducted the investigation, their own investigation. I think that report they put everyone. The solution is there.
Where is that?
Cross-examination.
Yes. Place due to unknown tractor. Taking place by driver. In PW2, there is no cross examination to help. Then PW3.
Second, the son has already given this. I have not stated before the police about this accident. He said the statement has not produced this state. I have not produced my identity card to address him. I have given history of accident to doctor. Also suggests that the content of Appellate soul by me.
I have given history of accident before doctor.
How can they get
So there is an evidence of 5 witnesses, which there is nothing to discredit their evidence. Police have filed a charge sheet against the rider of the said vehicle.
When it won investigation before, the after the vehicle said to have been caused the accident as been stated by injured.
No. No. He was severely injured. Somebody was taken to him. That is the PW2 has taken to the. No. 2 vehicles. That's the PW3 is going on another vehicle as a pillion rider.
Yes, of the claimant is that other two-wheeler caused the accident. When he was oriented, the of admission to the hospital, he only has stated which vehicle has caused it. That is recorded in the evidence. Not at the undisputed point of time, to the video. Whether it is victim or factor. Factor is mentioned in all the hospital records.
No, in one case, if it is wise, if once it is recorded, it is going in all the records. They don't have to discuss every time. No, they've given the complaint immediately next day. Police have conducted investigation. They found that the vehicle is involved. A case is registered against them. So why can't we take it as while mentioning, while taking the same, they have written it as tractor. He's driving a Victor bike.
No. He was conscious and oriented. That is what mentioned. The history of RTA two-wheeler patient was traveling hit by a tractor at 9 AM on 8/3/2010. But Algo is specifically mentioned in all medical records. Today by the patient himself.
So what do you say about this? 9/3/2010, they gave the complaint. And this is mentioned. After that, police have conducted investigation. Filed a charge sheet against the said vehicle. That the documents are there on record. Medical records not on RTA issue. Please pass on that.
In contention of the appellate before University as well as before the High Court was that it did not occur any injury in accident involved in the bus of the corporation. A reference was made to the evidence of doctor who had admitted the deceased to the hospital. That the deceased had suffered head injury to fall from height of.
There is no ratio laid down in this case. It's just based on the facts of the case, some order of 10 lines. No, correct, but it's just 10 lines order.
The vehicle causes accident, the injured people of the tractor, but not affecting.
Then we will come to the next part of it. That I heard about the next, what are the injuries sustained by him?
Not discussion. Negative. People are not proceeded. The evidence of failure to prove, yes, the evidence of the injuries.
No, but for granting compensation, other aspects have to be gone into your medical bills and all.
Let's say this. Let the matter go back.
Please come. There is an appeal filed by the claimant, agreed with the award passed in ABC number 1882 of 2010, dated 28th January 2012. The claim petition is filed seeking compensation of an amount of rupees 4 lakhs. Is filed, agreed with the dismissal of the claim petition. The claim petition is filed seeking compensation of an amount of rupees 4 lakhs. It is a case of the claimant that on 8/3/2010 at about 8:45 AM, petitioner was proceeding on a motorcycle as a pillion rider. The petitioner's son was riding the said motorcycle. At the time, another motorcycle rode. The driver of the another motorcycle, rider of the another motorcycle, rode the same with high speed and in a rash and negligent manner, came from opposite direction to the extreme right side and dashed against petitioner's vehicle, resulting in which he fell on the road. He has sustained fractures of both bones of right leg, fracture of right leg, great toe, and other injuries all over his body. He was shifted to Malavali Government Hospital. Immediately after the accident, he was given first aid. Thereafter, he was referred to Sanjay Gandhi Hospital for further treatment. He has taken regular follow-up treatment after discharge from the hospital. And incurred several amounts towards this treatment.
High Court has gone.
Right. What did you write?
He went for follow-up treatment after discharge.
And he has spent huge amount.
Amount towards the treatment.
The tribunal has considered that as per the hospital records, it shows that the claimant has met with an accident that the offending vehicle is a tractor, which is mentioned in all the medical records. Basing on that, the claim petition was dismissed, considering the discrepancy in mentioning of the the offending vehicle. As per the claim petition, it is a two-wheeler, and as per the medical records, it's a tractor. The Land Council appearing for the appellant submits that the incident has taken place on 8/3/2010, morning at 8:45 p.m. Immediately he was admitted in the hospital, and on 9/3/2010, his son has given the complaint. And in support of the accident, he has examined PW 3 and 4 or 2 and 3.
3 and 4 eyewitnesses.
PW 3 and 4, who are the eyewitnesses to the incident. He submits that by examining them, he has adduced the evidence to show that a two-wheeler is involved in the accident. He submits that the bike in which he is traveling is a Victor bike, on which he was traveling as a pillion rider, was a Victor bike. And when a statement was given to the police, it might have been mentioned as tractor.
Statement to the doctor.
Doctor. He might have mentioned it as when he has stated Victor, it has been written as tractor. He submits that in respect to the same incident, when a complaint is given, police have conducted the investigation and a charge sheet is filed against the owner of the two-wheeler, against the owner of the two-wheeler. He submits that itself shows about the involvement of the two-wheeler. It is submitted that when the claimant has sustained injuries and also a disability, and the court below more on hyper-technical ground have this petition. Land Council appearing for the insurance company submits that that it is the Honorable Apex Court in several cases it is settled law, and that the credence has to be given to the medical evidence. In this, at the earliest point of time, they have mentioned he has given a statement before the doctor. He has disclosed to the doctor that the offending vehicle is a tractor. Now, for the purpose of claiming compensation, they have implicated the two-wheeler. As per their own documents, as per their own evidence, the two-wheeler, the tractor is involved in the accident, and whereas they have filed the petition against the two-wheeler, as such the court below has rightly dismissed. This court has perused the entire material of the court. No doubt, in the hospital record, it is mentioned as tractor, whereas in the police record, it's mentioned as a two-wheeler. This court finds force in the argument of the Land Council for the appellant that the vehicle that is involved is a Victor motorcycle. That might have been the owner, the doctor might have heard it as a tractor, because the police have conducted a thorough investigation and found that the vehicle is involved in the two-wheeler is the offending vehicle which is involved in the accident. And the charge sheet is also filed in view of the same. And these circumstances, this court deems it appropriate to remand this matter for fresh consideration to the court below. Accordingly, the order under appeal is set aside and the matter is remanded back to the trial court for consideration. Shall consider shall pass orders shall decide the petition within a period of 2 weeks from the date of receipt of the copy of the order. Both the parties may be, both the parties are at liberty to read further evidence, if any. Order copy, order copy within 1 week. We'll say 1st of September. Both the parties shall appear before the court below on 1st of September.
Court observer. Court observer.